Yes, good morning, Mr. Howard.
Good morning, my lord. May it please your lordships. In this matter, I appear with my learned friend Miss Lucille Taylor on behalf of the appellant, my learned friends Mr. Hugh Sims, King's Counsel, and Mr. J. Gacia appear for respondents. My lords, before I start, I wondered if it would be helpful if I were to indicate in broad terms the scheme in which I intend to put my submission, so that your lordships can tell me whether that is convenient or inconvenient, or whether you would prefer some other order of matters.
Yes, well, you don't have to be too terrified of it all, Mr. Howard. Just tell us what you're going to do. We'll listen. It's my job.
My lord, I hope that at my advanced years I'm not that terrified. It's simply a question of what is going to be of greatest assistance to the court. So I was going to start with a few sentences of introduction. Then I was going to look at the appointed representative agreement. And then I was proposing to show your lordships some documents in the supplemental bundle which go to the background. Then I was going to move on to make some points about section 39 and the way in which that has been interpreted in the Anderson case in this court. And then look in more detail at what is in my submission the heart of this case, which is the what versus how distinction, and that is how I intend to refer to it, including showing your lordships perhaps where its genesis lies, which is in the case of Ovcharenko. And then I was going to make, having laid that perhaps rather lengthy background submissions on grounds 1 and 2 in that order.
Okay.
What seems to be missing, Mr. Howard, is how FSMA works.
Well, my lord, I was hoping to pick that up via Anderson, but I can by all means take that now.
Well, as long as it happens sometime, that's fine. I mean, we've got all sorts of words in section 39 which seem to cross-refer to other parts of the Act, like authorised person,
Yes.
prescribed, and all the rest of it, which we don't seem to have in our bundles at any rate.
Right. Well, my lord, if it would help, we can look at the way that is described in Anderson now.
Mr. Howard, but the problem seems to me that if you weren't authorised to undertake this business, it's quite hard to see how you can authorise somebody else to undertake this business, whatever you may have thought or not thought.
Yes.
And that if the liability under section 39(3) is collateral with the authorisation,
Which it is, my lord, yes.
which apparently it is, then you don't really get to first base, whatever the contract means. And that's, but one has to be satisfied, come at that through the legislation, because this is a statutory liability. It is nothing more nor less, and if the statute doesn't provide for the liability, there's no liability, beginning and the end of it. I mean, there may be liability for all sorts of other things.
And as my lord may have seen from the judgment, Mr. Stanley KC canvassed the possibility, which was not pleaded, and therefore he didn't have to deal with it, that there might be some sort of liability in terms of joint enterprise in general law of tort.
But it's not quite how you put it, is it? That's not quite the way I expressed it.
It's not the way anybody has put it.
No, sorry, I'm not talking about the other liabilities that would have to be determined at trial.
Yes.
But that it's quite a simple case that the statute does not provide for liability because this was outside anybody's authorisation, including your own.
Well, my lord, there I think one has to be a little careful with the greatest respect, because
Yes.
it is perfectly true that my clients were not authorised to operate an unregulated collective investment scheme.
They were authorised to market one?
They were authorised to undertake marketing endeavours in relation to products that might have included, I must accept, an unregulated collective investment scheme. But we say that we made it perfectly clear, first of all, that we were not permitting JHM, if I may call them that, to dealing in any way in unregulated collective investment schemes, and secondly, that we were not permitting them to deal in any way with retail clients, which all these claimants, apart from one, claim they were. And those are the two bases, as your lordships would have seen from the judgment, on which we contended that we did not give that authorisation.
Well, I think it would be a good idea to start where my lord suggests with the Act.
By all means, it may perhaps be most convenient to start in Anderson in the Court of Appeal, because the relevant sections of the Act are there set out and explained by Justice David Richards. I can get my authorities. And this is tab 2 in your lordship's bundle of authorities, I hope. Decision of the Court of Appeal in 2019. And the exposition, if I can call it that, starts on internal page 5 of the report, page 15 of the authority bundle numbering, which is at the bottom. But it's regulatory framework, halfway down the page.
So which paragraph is it?
It starts at paragraph 10, but really for present purposes at 11,
Yeah.
whereby the essential characteristic of FISMA with which the court is concerned is set out.
Mm-hmm.
You have to be either authorised or exempt in order to conduct financial services activity in this jurisdiction. Authorisation is direct from the FCA, and authorisation is what my clients had, and your lordships will be taken, if necessary, later to the authorisations they have, which is set out in the register, and we have a copy of that in the bundle. Exemption comes in a variety of forms, but the most common one in practice, and one with which your lordships are here concerned, is by way of authority given to a person under section 39. So the authorised person is enabled to, as Lord Justice David Richards put it at 13, outsource that to his appointed representative.
Just to dwell for a moment on paragraph 12.
Yes.
As I understand it, section 31 of FISMA defines an authorised person as a person who has a Part 4A permission to carry on one or more regulated activities.
Just saying, look.
So the question arises, if you are permitted to carry on one regulated activity, are you an authorised person as regards all regulated activities? Or are you only authorised as regards that which the FCA has authorised you to carry on?
The latter.
The latter.
Yes.
I would have thought that was right. So it's essential, therefore, to the current case to establish that your clients were authorised to have some connection with, put it loosely for the moment, collective investment schemes.
Well, I'm not sure that is quite right.
Why is that?
Because the authorisation does not proceed in relation to particular products in quite that way.
Right. Now, permission is granted by the FCA under section 55E, and that enables the FCA to give permission to carry on regulated activities, or such of them as may be specified in permission.
Yes.
And section 55E5A gives the FCA power to incorporate limitations
Yes.
in the description of regulated activity. And when we look at the authorisation, in this case, limitations in relation to a number of different activities include the client to whom
They do,
the
Michael,
activity
yes.
is marketed.
Yes. Would it help if we turn that up? Because I was going
Well,
to
you're going to show us the way the scheme works via Anderson, but we will need to look at it in due course.
Well, as my lord has raised the point, I wonder if it would be convenient if we looked at my client's authorisations while it well, as it were, on the topic. And those are to be found in the supplemental bundle at tab 11.
Page 86, is it?
That is where it starts, my lord, indeed, yes. And this is a printout from what you can get from the register. And my lord see my client's firm name top. And there are various bits of information about the firm, but it really starts at 91. And this is at 91 a permission to advise on investments except on pension transfers and pension opt-outs, which, as my lords probably know, is a particularly specialist area. And as my Lord Justice Lewison has pointed out, there is a limitation, and we say this is important in the present case: customer type, eligible counterparty, and professional.
What's an eligible counterparty?
An eligible counterparty, my learned friends Junior caused very helpfully Corpse 3 to be sent to the clerk, to the Lord Master, the Vice Chancellor, well, Master Roll, sorry, this morning. An eligible counterparty is effectively a legal rather than natural person, if I can put it in very, very brief terms. Whereas a professional client can be a natural person, and a professional client can, as it were, elect to be so treated. Well, if I can take you to the precise definition if it would help at this stage.
Hobbes 3.6.
It's in fact 3.5.3 is the elective.
Right.
The natural person can only be a professional client if they elect to be so. They're not what's called a per se.
That is right, my lord, and moreover, there are two steps in it.
Yes.
First of all is that they must, in the jargon of the industry, elect up to that status, but also it is right to say that the firm has to undertake an assessment to see if that election is realistic, and I put that in very broad terms and by way of précis of what the rule says. But there are two requirements for an elected professional client. And a retail client is somebody who is neither professional nor an eligible counterparty, so it is, as it were, the default setting. The point for present purposes is that, at least as regards advising on investments at page 91 of the supplemental bundle, my lords will see that customer type does not include a retail client, but by way of contrast, if my lords turn to the next page, page 92, under arranging brackets bringing about deals of investments, the customer type can be an eligible counterparty, a professional, or a retail brackets.
Which of these activities relate to collective investment schemes?
My lord, I believe in principle they all do, right? Because my lord sees the word unit at the top of page 92,
Unit.
which is part of the investment type list, which begins on page 91.
So where's unit?
Top of page
Next
92,
page.
my lord.
Yeah.
And also again, top of page 93, the list is inconveniently between the two pages.
And
There
is
it.
that defined somewhere?
It is somewhere, my lord. it's not, I don't think, in the materials we have, unless Malone Friend Mr. Jagasha believes he can help us on that.
I think we've included. I'll find reference for you.
At any rate, you say it includes collective investment schemes.
Units therein, yes.
It's section 237 of the BISMA. In the definition section, it's sub 2.
I'm told it's page 298 of the authorities bundle. My grateful to Mr. Sims and Millen Jr.
298.
Yes, that will be behind tab 14. Indeed it is. This is part of BISMA section 237. And if my lords have the top bit of the page, units means the rights or interests, however described, of the participants in a collective investment scheme.
Right.
While I was looking just briefly at my client's authorisations, we say it is relevant to note.
So why does the judge say that you weren't authorised?
Well, the judge says we weren't authorised to operate a collective investment scheme. That, I think, is right. The judge takes a distinction between the operation of the scheme and other activities such as advising and arranging deals in respect of it. And we say, and I will come to this, that is too fine a distinction. But that is, as I understand it, what the judge was saying, and he was right about it.
Yeah. It seemed to me to be a tension between what he said at paragraph 38 and what he said at paragraph 53.
Well, Lord, I'm sure will explore that with me further if necessary. But the important point we say about these permissions on a higher level is that the FCA itself circumscribes our permission by reference inter alia to customer type. And we suggest that means that the judge was wrong when he said that retail client or not was a how, not a what. Because the very permission which we are passing down, so to speak, to our appointed representative can be and is circumscribed by reference to the type of client. And we suggest that that is a very powerful indicator to the effect that retail client or professional client is a what you are allowed to do, not a how you are allowed to do it. And I will, in due course, come back to that. But I make the point at this juncture because we're looking at this document. But, Lords, I think we were looking at the scheme of the Act, and I was in Anderson in the Court of Appeal, tab 2 of the authorities and following on from paragraph 11, paragraph 13 describes the effect of appointing an appointed representative. Regulation of ARs may thus be said to be outsourced by the FCA to the relevant authorised person, designed to reduce the regulatory burden on both the FCA and the large number of tied agents and independent financial advisors whose activities are conducted on a modest scale. So that is what section 39 read with section 19 is intending to do. the way in which the regime further works is that the principal of an appointed representative is responsible, as your lordships would have gathered under section 39, for activities within the scope of the position, whether or not expressly authorised, and even if they would have been forbidden had the principal known of them. But equally, and perhaps unusually, the principal is required to supervise the agent, and that is in my submission, creature statute. There's no such thing. Common law is a duty to supervise the agent. One is either liable for the agent under the usual doctrines, or one is not. But there is a supervisory element imposed by FISMA. And that is important in terms of the way the statute works, in terms of the way section 39 works, because if the principal, in this case my client, is going to be liable for anything done or omitted within the scope of the permission, then it follows, we submit, and this is what the Court of Appeal dealt with in Anderson, it follows that the principal is entitled to and should be entitled to circumscribe the authority which he gives to his appointed representative in order that he may more effectively supervise the activities of that representative. And on the facts in Anderson, what the principal did was say, well, you have permission to carry out these activities, but you must do them through a company agency, that is to say, an agreement which the principal had with the provider. So, for example, the agent was entitled, shall we say, to sell an investment bond provided by Scottish Widows because there was a company agency, but they were not entitled to sell an investment bond provided by X PLC because there was no agency. And in this way, the principal was able, in the Anderson case, to keep a track on what business was being done because it could match the business going through its records, company agency, against the financial information with which the appointed representative provided it. And that was critical to the workings of the supervisory system in that case. And it's perhaps partly for this reason that the Court of Appeal in Anderson accepted, contrary to the submissions made by the claimants in that case, that it was permissible to impose restrictions, as it were, within the type of business for which permission had been given. The claimant's argument in that case was that if the principal grants permission to carry out a generic part of the business, generic part of financial services business by reference to the various regulations that define those types of business, then the permission relates to any form of business that falls within such a generic category, and the Court of Appeal was against that. And of course, find that.
So just see how that would work in our case.
Yes.
You authorise your representative to carry out certain types of business.
Yes.
But because you put on a limit that's only to certain types of customer, the
yes.
supervision obligation would include some sort of checking to make sure that they are only marketing and selling to those categories of investor. Is that right?
That is right.
Yeah.
And in the bundle, and I can take you to it in due course, in the bundle we have an example of a claimant in this case who has, in the jargon, opted up to be a professional investor and has signed the necessary certificate and that would be, we're not concerned with breach of the SEP rules because the judge rejected the application on that ground, but that would be an example we submit of what the principal has to do. He doesn't have to second guess everything that the appointed representative does, but it might be in a hypothetical case where there was nothing at all on the file to suggest or to support the categorisation of the investor as a professional investor. There might be a well-aimed allegation of breach of the supervisory rules.
So if, for example, you have natural persons who are investors,
Yes.
then they clearly can only be within the authorised categories if the appropriate processes have been gone through, so that the supervision obligation would be likely to include some sort of obligation to make sure that those checking arrangements were in place. Now that's a way I think the case is put against you, but the judge said that's a matter for trial. But that's an alternative route,
Yes.
potentially, to your liability.
Indeed is, my lord. But my lord has, if I may respectfully say so, the point about how the supervisory process works. And of course, what we say follows from this is that we are entitled to circumscribe our permission, in effect, by any means we choose, if it is tailored to enabling our systems to work in that way. So in this case, largely because with a couple of exceptions, my client's permissions from the FCA did not extend to retail funds. We wanted to make sure that there would be no marketing of retail funds. And the second reason, or the second limitation, I should say, that we put upon the business, or sought to put upon the business, was that there should be no dealing with unregulated collective investment schemes. Those schemes, even before asset landed in the Supreme Court, and as the judge very fairly recognised in the judgment, those schemes were always difficult and complex, and my clients took the decision that they did not wish business to be done in relation to that sort of a scheme. And that is something, in our submission, they were perfectly entitled to do. And of course, the question before your lordships is whether the judge was right to say we did not effectively do that. No matter what we wanted to do, we did not effectively do it. But my lords, if I can return so that we go through, as it were, the statutory mechanism and how Section 39 works, if it's convenient, we might perhaps go to paragraph 32 in the Anderson case in the Court of Appeal, tab 2, page 20 of the authorities bundle. And at paragraph 32, Lord Justice David Richards explains that an appointed representative is someone whose activities in carrying on the whole or part of business the authorised person's accepted responsibility in writing. And he unpicks a number of points that come out of that. The first is that because the acceptance of responsibility must be in writing, it will, reading from letter C, it will be necessary to refer to the terms of the document by which the authorised person accepts responsibility. And here, of course, that takes your lordships back to the appointed representative agreement. Omitting the next sentence, the words "the whole or part" demonstrate that the acceptance of the responsibility need not relate to all activity that could fall within a generic type of business described in the AR regulations and specified in the AR agreement. The acceptance of responsibility may relate to part only of such business as stated in the written acceptance of responsibility, which is, if I may say so, a rather more eloquent way of putting the point that I was making a moment ago. We can introduce a carve-out. And then he says at 34, between letters F and G, this, which I suggest is important. If an authorised person has accepted responsibility for any part of a category of business, the AR will be exempt only in respect of that part. This makes sense. Acceptance of responsibility is the equivalent of authorisation and is essential to the enjoyment of exempt status by the AR. The AR will be subject to the general prohibition as regards any activity falling outside the business or part of the business for which the authorised person has accepted responsibility. So that's a fairly clear statement.
Well, what is the position if you have a contract which appears to exclude something, let's
Yes.
say collective investment schemes, but you do in fact know all about the schemes which are being marketed, and you do in fact approve the representative to market them to investors? How does that
That
fit
is,
into section 39?
if I may say so, my
It
lord,
does.
the nub of ground one, I think. We say that we have made it clear if the appointed representative agreement is read contextually, and I'll come back to what I want to say about that perhaps later. We had made one thing clear, which was thou shalt not touch an unregulated collective investment scheme. Now, when the agreement was made, I think the evidence shows that neither party to these proceedings thought that the scheme was, in fact, an unregulated collective investment scheme. My learned friends on the other side say, well, that's a question of label. They got the label wrong. I suggest that that's too simplistic an answer with respect. This is a question of the attributes of the scheme. So the false label line of cases doesn't take us anywhere.
Sorry, what do you mean by the attributes? The attributes are the attributes of the scheme, and it's now accepted that those attributes made it a collective investment scheme.
That's quite right, yes. But the consequence of those attributes and the legal conclusion to which they led was not understood by the parties at the time.
Why is that any different from Mr. Street not intending to grant Miss Mountford a lease, or her intention not to take a lease, but that's in fact what they did?
Because the agreement in Street and Mountford is an agreement between the two parties to the litigation. In this case, what we have is an agreement between my clients and the appointed representative, under which there sits a further agreement between JHM and the investors, which turns out to be an unregulated collective investment scheme. And it is that layering which I suggest makes the difference, because in Street and Mountford, as my Lord rightly points out, the parties, to use Lord Templeman's analogy, by their agreement created a fork and then labelled it a spade. But in this case, we have an agreement, as it were, that sits over the top, and part of that agreement says you will not market, you will not deal with unregulated collective investment schemes. But it is not a case in which the parties have, inter se, agreed one thing and labelled it another. And we say that's an important distinction. And we also say, if I can take a Lord Justice Nails' point, we also say that this is, in part, a question of allocation of risk, not specifically, not in the way in which one might commonly find risk to be allocated in a contract. But we do say that this is a case in which appointed representative JHM wished to have the benefit of, in effect, our statutory licence. Wished us to take the burden of supervising and taking liability under Section 39 if appropriate. But if someone is to seek to take those benefits, and the person who wishes to take those benefits, being the appointed representative, is the person with the intimate knowledge of what is being done and how it is being done and what it might amount to in law, then if the answer is at the end of the day that the parties got it wrong, this was an unregulated collective investment scheme and nobody realised it, then the problems with that ought to lie with the appointed representative.
But that submission depends on the representative having what you describe as intimate knowledge of what was being done, and the principal not knowing. Suppose a case where they both know exactly what is being done and what is being offered to investors, and where the principal either approves that or certainly doesn't say, hold on, you can't do that, but they have a contract which says, no, you mustn't touch a collective investment scheme. What then? Why does knowledge?
My lord, the cheat answer to that is that is not this case. But I need to confront the Lord's question head on. I would suggest that even in a case where both parties are advised, I mean, let us suppose that these parties were much more sophisticated than in fact they were. Let us suppose we're dealing with two large entities, both of whom are advised by experienced solicitors. My answer to my Lord's question would still have to be that in the end, when the chips are down, if I can put it that way, it is for the appointed representative to carry the responsibility of the fact that the product turns out, as in this case, to be an unregulated collective investment scheme, because it is the appointed representative who is proffering the product and seeking to take the benefit of the authorisation. But as I've said, my lord, I appreciate the reason that the point is put to me, but that is not the position in this case on the facts.
Thank you.
So we were looking at Anderson, and I think, got as far as paragraph 34. Paragraph 35, just while we're going through it, and I've alluded to this already, but it makes the point at the very bottom of the page by letter H. As the quid pro quo for accepting responsibility, the activities of an AR and carrying on the whole or part of the prescribed business, and thereby exempting the AR from obtaining internal authorisation, the authorised person becomes personally liable to third parties for the AR's acts or omissions in the course of their activities. And I think the Lords have already noted this. Exemption liability under 39.3 are coextensive. And at 37, and again I think this confirms a point that the court has already put to me, at around about letter D, dear my lords, have an authorised person cannot accept responsibility for a business for which it does not have authorisation from the FCA. And that may
Well, that's Mr. Sims's submission, isn't it? I think.
I believe it is, but I believe also that the Court of Appeal accepted that. And I don't think, in fact, Mr. Sims will correct me, casting my mind back, I don't think that proposition was an issue for the Lordships in that case. But in fact, 37 as a whole, I think, is more decision rather than citation of a friend's able submissions in that case. At about letter E, and this is important again, with respect in understanding how 39 works, Lord Justice David says it may make perfect sense to limit an AR to a partial exemption, having regard to the breadth and depth of the expertise of that AR, or indeed of the authorised person. Now that sentence is commonly referred to in the context of, well, what does the AR know? How able and experienced is the AR? But it is important to see that Lord Justice David Richards talks of the breadth and depth of the expertise of the authorised person, which, in the context of the present case, amply justifies the suggestion and the attempted limitation by my clients on the basis of, well, we don't want to have anything to do with unregulated collective investment schemes because they are notoriously difficult. And then one comes, turning a page, paragraph 40, to the major point in terms of construction of Section 39, which is established in this court by the Anderson case. And at 40, my learned friend Mr. Simpson submitted that even if statutory responsibility may be restricted to any part of a business, liability cannot be excluded by reference to a failure properly to conduct that business. Lord Justice David Richards said, I agree with that, and that is not in contest. He's obviously correct. But I do not agree with the next submission that it's impossible to distinguish between what and how, so that the only sensible answer is to define the authorised person's responsibility by reference to its authority to conduct business of a prescribed and generic description. In my view, it would be a rare case which presents any difficulty in distinguishing between what activity may be carried on and how a permitted activity is to be carried on. And so that is the genesis of the what versus how distinction which lies at the heart of this appeal.
But I think you would also say, wouldn't you, that even if Lord Justice David Richards had accepted Mr. Sims' submission, you would then still need to go to the authorisation given by the FCA, and you would see certain limitations.
Yes. Now that was not in issue in Anderson's sense on the facts, but I would certainly say that. Yes. And the classic example, and it may be that I don't need to take the laws to it, but the classic example of the fallacy of trying to restrict how something can be done is the case of Ovcharenko, which is an gorgeous pun, but I don't even need to glance at it. But that was a case in which it was valiantly argued for the principle that the following analysis worked. A, the principal had, in the contract, said to the appointed representative, you must do things properly in accordance with the rules and in accordance with the appointment duties. B, the claim now made by the claimants is that you missold the product. Therefore, you have breached your obligation to act in accordance with your duties. Therefore, I am not responsible. Judge Waxman QC, as he then was, said, and quite rightly said, well, that's impossible. Because if the principal were entitled to fasten upon any error by the appointed representative in terms of what we might call the use of proper skill and care, that empties Section 39 of any content at all, because Section 39 is obviously only relevant if the appointed representative has breached his duty to the claimant. So that can't be right, and I think anyone disagrees with that. But that is the genesis of Lord Justice David Richards' distinction between what is permitted and how it is permitted to be done. And just before we, as it were, close up Anderson's sense in the Court of Appeal, the finding on the facts is important in my submission. The Lordship's find that at paragraph 57 on page 15, internal pagination report 25 of the bundle. In my judgment and in agreement with the judge, the restriction in clause 3.1, business using a company agency, constituted for purposes of section 39, an acceptance by sense of responsibility for part of the generic business prescribed in the AR regulation. Advising clients to entrust their money to the scheme being operated by Midas and Mr. Gregg did not involve the use of a company agency and therefore fell outside the business for which sense of accepted responsibility. And the reason I draw attention to that in the facts is that the stipulation made by the defendant in that case, which was effective to mean that it was not liable under section 39, was the use of a company agency. And as I have earlier submitted, that meant not that the nature of any particular product was prohibited, it was that it had to be done through the company agency. And that was a what, not a how. And what is not, subject to hearing from a learned friend and with respect, what is not being explained in this case is why the stipulation you can't market to a retail client is different from you must use a company agency, or to put the proposition the other way, you must not do business that is not within a company agency. And the learned judge does not, in my submission, anywhere in the judgment, confront this. We, in fact, say that the present case is a stronger case, that the stipulation, certainly about retail client, is a stronger stipulation. But the judge does not anywhere explain why Anderson and Sense is to be distinguished from the present case. On the judge's approach, which is that these things are how and not what, well, why isn't use of a company agency a how? Answer, the Court of Appeal and the learned judge, Mr. Justice Jacobs, decided that company agency was a what? And we suggest there's a good reason for that. That going back to the Ovcharenko decision, the fallacy of if you commit a breach of any of your duties of skill and care, that means that the principal is not liable under 39. That's clearly fallacious. But what follows from that? Well, we suggest that stipulations in relation to status, whether it be the status of the advisor or, in this case, on my ground 2, status of the client, are, as it were, what's, not how's. Because let us suppose that the advisor in this case gives advice to somebody who is not a retail client, and certainly the process of making that person an elected professional client has not been gone through. So default position, retail client. But let us also suppose that the advice is suitable, that it has been preceded by an appropriate process of knowing the client, finding out aims and objectives, all the steps that are taken in relation to the normal advisory process. And suppose that the product is then sold and doesn't cause any loss. Well, what's the position then? We say that that would still be technically a breach of the appointed because all the process, all the hows would have been correctly done. One could go through and tick all the boxes, but still it would be a breach of the appointed representative agreement in this case, because the what, namely to whom this should be marketed, would not be satisfied. And that would matter, even if there were no monetary claim that resulted, it would matter because the appointed representative would be acting out with the permission granted, thereby in breach of Section 19, the general prohibition. And that would be not only a criminal offence, potentially under Section 23 of the Act, but also something that the regulator might not be impressed by. Now, that submission was made to the judge, but he doesn't address it in the judgment. It was made by way of trying to illustrate the difference, as I've already submitted, and I apologise for repeating myself, the difference between how and what. If we assume a perfectly satisfactory and skillful process, but directed at the wrong person, then that's a breach of the what. And one can turn it around the other way.
Well, you could get it from the authorisation.
Yes.
I mean, if you, the FCA is telling you what you can do
Yes.
in its authorisation, not how you do it.
Yes.
COBS tells you how to do it and all sorts of other rules, but the authorisation tells you what you can do.
Yes. Well, I apologise if I'm labouring the obvious. And certainly my starting point for today was going to be we can get all this from my authorisation.
Yes, I mean, the judge doesn't seem to have dealt with the authorisation very much.
Well, look, I'm bound to say that I did not draw this point to his attention.
Right.
As he records at the very end of the judgment, I picked up this brief at fairly short notice. And I must confess it did not occur to me, even when I settled the papers for the appeal, that having made that confession, what I would suggest is that better that a good point that occurred to me later than I not put it to your lordships at all. That it would be unfair to the judge if I were to suggest that he overlooked that point because it simply wasn't an issue. It wasn't argued before. What was argued, obviously, was the importance of the status of retail client, but this particular point tied back to your authorisations, I confess I did not make. My lords, I was going on, and if I may just take 2 sentences to complete the point, as it were, the other way round about permissions. One can envisage a pension transfer case. The lords will note there's been a fair amount of litigation and dispute in relation to transferring occupational pensions into private pensions. The rules around that are quite prescriptive. Pensions advisors have to hold certain particular qualifications before they can advise on a transaction of that sort. And again, let us suppose that a pension transfer piece of advice is given with perfect skill and care and is undoubtedly the right thing to do, but if it is given by somebody who doesn't hold the qualifications, and if it be supposed that an appointed representative agreement contains a stipulation that an advisor must hold those qualifications, then again we would say that's a question of status, of what is being done, not how it is being done, and that be it done never so carefully, it would still be out with the authorisation given with the consequences to which I have just referred. So, Lord, if I can just have a moment. What I have not yet done, which I promised Master of the Rolls first thing this morning I would do, is take you to the appointed representative agreement.
Sorry, I'm sorry to bang on about FISMA because I'm not sure that I've quite got on top of it. One of the requirements of an agreement which satisfies Section 39
Yes.
is that the AR must be appointed to carry on a prescribed activity. That's the phrase.
One has to be a little careful there, my lord. He has to be appointed to carry on particular business, and as we've seen, that can be done by reference to generic activities, as prescribed in the various regulations, or it can be done in relation to any part of
The
that.
agreement must permit or require him to carry on business of a prescribed description.
Yes.
And as I understand it, prescribed means prescribed by Treasury regulations.
Yes.
And we've got two regulations in our bundle. One is the Financial Services and Markets Appointed Representatives Regulations 2001,
Yes.
and the other is the Regulated Activities Order 2001.
Yes.
Which of the activities are the relevant activities for the purposes of this AR agreement? Which are the ones in either of those orders? But again, I don't think the judge identifies what the relevant prescribed activities, what the business of the prescribed description actually is. And I would like to know.
Yes.
At some point, it doesn't have to be immediate.
Well, it may be that I would need to think about that for fear of misleading.
Yes, well, for a novice, it's not that easy to trace your way through these particular orders. And in particular, there's something called a relevant investment referred to in Article 25 of the Regulated Activities Order, and I have no idea what that means.
Well, my lord,
Mr. Sims
even
may
if
be
one has a
able to-
modicum of experience, it's very difficult. I will defer to my learned friend.
My lord, the judge does allude to it in paragraph 15, the two categories of the judgment.
15. Paragraph 15.
Paragraph 15, yes. So he refers to the two different categories referred to there of advising of investments and arranging deals of investments. Doesn't refer to the
Sorry, I'm
the articles. Paragraph 15 of the judgment below.
paragraph
No.
1.5.
No, I think so, yes.
Yes, in paragraph 15 of the judgment below.
Starting the investment schemes which have led to this claim were conceived between 2015 and 2018. That one.
Give me a moment. Sorry, paragraph 4. Sorry, it's paragraph 14.
14.
14. And my apologies, and they're the same paragraphs, in fact, which are picked up on in Amazon says. I think it's paragraph 15 in Amazon says. Apologies, I was looking at the wrong document when I referred to the different paragraphs. It's paragraph 15 in Amazon says, paragraph 14 of the judgment.
So this is within, is it within regulation 2(1)(a) of the appointed representatives regulations? Is that how it works? And that then takes us to Article 25 of the Regulated Activities Order. And that's arranging deals in investments. And is a unit, what is a unit? Is that a relevant investment? Where do we find the definition of relevant investment, which I couldn't see?
Specified investment.
Yeah.
I think.
That's in the RAO.
Article 25 of the Regulated Activities Order talks about making arrangements for another person to buy, sell, subscribe for, underwrite a particular investment, which is a security, a relevant investment, an investment of the kind specified by Article 86 or 89 so far as relevant, or a structured deposit. Now, which of those is a unit?
Well, my recollection is that a unit is within the definition of relevant investment.
Well, that's what I wondered, but we don't seem to have the definition of relevant investments. Again, for a novelist, it's not so easy to trace your way through this.
Lord, I entirely appreciate that. It may be something that council can help with over the short adjournment.
Well, yes, there is a route through, but in relation to CISs, they're commonly recognised as a specified activity falling within.
And it comes in because it's a relevant investment. Is that how it works?
Yeah, that's my understanding, my Lord. Yes, the order itself is an absolute maze of definitions and cross definitions, but we will see if we can pluck out the important point without having to take your lordships all the way through the mess that leads to it. Now, of course, there's a point that's made behind me, and lordships have apprehended this already. We did not believe at the time that this was an investment in a unit because we didn't
follow.
Lord has that. And the other, I apologise again if I'm telling your lordship how to suck eggs, but the label unregulated collective investment scheme actually refers to what's held within the scheme. But it's a perhaps rather silly piece of nomenclature because it leads one to think potentially that it's outside the regulatory umbrella, whereas it isn't. That's one of the difficulties. So, my Lord, what I was going to do next, if I may, unless there's anything else I can help with at this juncture, is just look briefly at the appointed representative agreement, which is behind tab 15 in the core manual. Well, the first point to make about this agreement is that when one reads it through, as I'm sure the court has done, it has a certain veneer of technicality and has clearly been drafted by somebody who's tolerably familiar with the industry, but it is not professionally drafted. We do not see a solicitor's logo on it. We do not, as far as myself and the learned community can find in the evidence, have anything within the evidence to say by whom it was drafted or when. But if we are looking at the, as it were, spectrum of sophistication of this agreement for the purposes of looking at it in context, as the authorities direct us to do, I accept that this is not a thoroughly informal agreement for the sale and purchase of a business drawn up on the back of a napkin by two unsophisticated parties. But I do suggest that if we are looking at the spectrum or the dial of sophistication, this comes on the unsophisticated side of the scale. And that is important in our submission, not because there are particular textual difficulties, but it is important to have that in mind when we are considering what it was that the parties were trying to convey, trying to record. On the first page of the agreement, page 171 in the bundle, what I might call recital B, although it's introduction paragraph B, we see again reference to professional clients and eligible counterparties, and a statement that the AR will not advise on and arrange deals for retail clients. So that's what we say clear. It is repeated in the definition of relevant business, which appears at page 175. Now, the judge made the comment that this definition was very nearly circular. Regulated activities which the AR is permitted to carry out under this agreement, and so on and so forth. But it does contain, and irrespective of the degree of skill with which that first paragraph was drafted, it again contains a stipulation that the business is to be with professional clients, elective professional counterparties, and eligible counterparties. A prohibition, and I stress that word because, of course, when one goes back to section 39, the statutory wording is about permission, the obverse of which is prohibition. AR is not permitted, so it's pretty clear what was being driven at there, if I may put it that way. And then we have, at the end of the final paragraph of the definition of relevant business, the judge drew attention to this. There is no pooling of capital and no CIS. Now, the learned judge took the view that that was a declaratory statement. It was a statement of the parties' mutual understanding. Now, of course, on one level that is correct, because it was what the parties mutually understood. But in my submission, it goes further than that in an agreement drafted in this fashion without professional assistance. It is a statement that is tied into and part of the definition of relevant business. It is a statement that makes sense because collective investment schemes, as the judge himself recognised, are difficult and complicated. It is true, of course, that the sentence does not read, the appointed representative will not deal in anything that involves building of capital or a CIS. But in my submission, it is pretty clear, and I would invite the Lordships to find in context, that that is what was meant. And so one comes to, and whilst, as it were, trotting through the agreement, I would ask your Lordships just to note in passing, clause 2.1, page 179, which is the usual provision that the appointed representative will do everything properly in accordance with the rules and its duties of skill and care. Page 182 provides for payment of fees. Again, the usual way in which this works. Fees are levied by the appointor in relation to compliance assistance that he gives. And then we come to Schedule 5, starting at page 192. And one needn't turn all these pages, but we looked at my client's permissions from the FCA earlier on, and the Lords will see, as is apparent from the subheading of Schedule 5, limitation of the appointor's Part 4A permissions. Those are faithfully reproduced, including the limitations on customer type. And then at the end, page 195, we have a for the avoidance of doubt provision in the middle of the page. The AR cannot, last bullet point reiterates yet again, give advice to retail clients. But bullet point 4, the AR cannot operate a collective investment scheme. And it's right to draw attention to, and I do draw attention to, the word operate. Because, of course, what's complained of here by the claimants is not the operation scheme, but advice and arrangement, and so on and so forth. But the judge, of course, said, he took that distinction and relied on. But he also said this agreement can only be construed sensibly on the basis that everybody knew the very business, the very schemes with which it was concerned. And the fact that nobody realised at the time that they were collecting investment schemes is not to the point. But what is interesting and illustrative in our submission is that true it is that this says you can't operate a collective investment scheme. But it must follow from that, we say in context, that they could neither advise nor arrange nor have anything else to do with it. Because otherwise, that involves the proposition that the operation of these schemes, admittedly through the special purpose vehicles, but the judge didn't think that was a difficulty. The operation of these schemes was out with the agreement, but advising and arranging and so on and so forth about those very schemes was within it.
Why not?
Well, there's nothing to, because of the law, there's nothing to suggest that the parties have that subtlety in mind at all. If the learned judge is entitled to say, oh well, because the subject
say,
matter...
well, you can advise on investments in an open-ended unit trust, but you can't be the fund manager. Well, there's nothing logical about that.
There's nothing illogical about it in principle, Lord, I accept. But where I'm attempting to found this submission is in the judge's conclusion that because the only subject matter contemplated for this agreement was the scheme, these very schemes, their very raison d'etre. What the agreement prohibits is the operation of a collective investment scheme. So the operation of these very schemes, which was something that JHM would do, is prohibited. But does it not also follow, in our submission, it does if one looks at the agreement in a broad way in the way the judge did, that any operations, any advice or arrangement in relation to those schemes would also be prohibited.
Well, it may depend on what the rest of Schedule 5 says, which at the moment I find a little opaque. Schedule 5 starts with the words limitations of the appointors, Part 5A, permission, right?
Yes.
And so that says, and then it sets out activity names and sets out, you tell us, things they can do, you can do, including units, which includes collective investment schemes, from your authorisation.
Yes.
And the only reference then to limitation is rights to or interests in both, which one assumes refers to customer types, although it's rather strange. So this is all under the heading limits on your permissions. First of all, you've got the activity name, and the limitation appears to be the limitation on the customer types, to the two types. Then you've got agreeing to carry on a regulated activity, which is limited to carrying on regulated activities. And the activity names once again include units. So, I mean, do we not have to look at exactly what this schedule is saying? Where is the schedule referred to in the rest of the agreement?
In the definition of relevant business.
Well, then anticipates me. I'm looking for it.
Which is on page.
It's 175. Relevant business means regulated activities which the AR is permitted to carry out under this agreement, which are subject to limitation with the appointors Part 4 permission as detailed in Schedule 5.
Well, Lord, I'm grateful. That is just so. Which, of course, reflects the principle that we've already discussed, namely that he who does not have permission to do something from the FCA may not purport to grant permission to
Yes.
someone else.
Yes,
It doesn't in fact faithfully reproduce the authorisation because, as my lord says, limitations seem to be rights of interest, for instance, in the first part, whereas if you go to the authorisation itself, the word limitations appears directly after the description of the investments, advising on investments except on pension transfers, etc.
Yes, so-
limitations.
So
So
the order is
limitations are
different.
everything that follows, as I read it, including customer type, investment type, and then rights or interest in both.
but I think my point, if I may just finish it,
Of course not.
is that the words for the avoidance of doubt, the AR cannot, have nothing to do with limitations on your authorisation, which is what this schedule is about, according to the definition in which it is referred to. And if we just read that as a freestanding clause, it is a freestanding clause that prevents the AR operating a collective investment scheme, which is contained within a schedule that recites the fact that you are authorised to deal in some way with units in collective investment schemes. And so my question is, why should we construe that limitation as going beyond the limitation to do what it directly says, which is operate a collective investment scheme, as opposed to, say, marketing one?
Look, can I make two remarks, in, I hope in answer to this question. First is that I would accept that this, for the avoidance of doubt section, sits rather oddly in terms of its location within the agreement, which brings me back to the point made earlier as to the degree of professionalism with which this is drafted. I accept also, my lord, and I'm seeking to confront the difficulty that what is prohibited in terms here is the operation of a collective investment scheme and not activities such as advising that and arranging. And so I accept that on a literal construction, the activities complained of in relation to these schemes are not caught by that bullet point because they are not operation but advice and so on. So, but I was seeking to come at it the other way, which is by saying, given the judge's bedrock point, if I can put it like that, that this arrangement, this agreement was concerned with these schemes and only these schemes. And given that JHM were indeed operating through SPVs, these collective investment schemes, it seems, we would say, a jump to suggest that the marketing and so forth of these schemes is actually authorised by this agreement. Because if this agreement was designed to enable these schemes to be operated, developed, so on and so forth, it is curious that the operation of them was in fact prohibited by this agreement. And it is, we suggest, too much of a subtlety and not really to be found in this agreement taken overall and in its context, for it to be said that my clients were content for these schemes to be operated, to be marketed, arranged, and so on and so forth, but not content for them to be operated.
Well, did
That's
the
simply
judge
the
say?
subtlety we can see.
Did the judge say that operation meant marketing and other things?
No, he didn't, and he was right not to say that.
So what do you say this schedule is to be taken as meaning? That they were not allowed to have anything to do with collective
Yes.
investment schemes? What, because of the sentence, the statement in the earlier part of the agreement,
Yes.
or because of Schedule 5?
Both together.
But the statement in the earlier part of the agreement is just that, isn't it? In the definition of, if we go back to the definition, sorry, I'm not very good on the pages. 175.
My lord, it's page 175, I think.
Yeah, we go back to it. I mean, it's within an acknowledgement that the AR will offer advisory and arranging services to third-party investors with regard to residential property investment. So that's what you're going to be, your agent or representative is going to be doing. And then there is a statement that there is no pooling of capital and no CIS. But that doesn't contradict the earlier part, that you'll offer advisory and arranging services to third-party investors with regard to residential property investment, which is what you did.
And my lord, I would accept as a matter of language that the final sentence is and looks like a statement.
It's a statement of what you thought, both of you. Just happened to be wrong.
My lord, I would accept that I would have grave difficulties in even advancing this submission if the agreement had been professionally drafted. And if it had been professionally drafted, one might, for example, expect to find a warranty or something of that sort. But I suggest that if one takes these references all together and one bears in mind the difficulties associated with collective investment schemes, what this agreement drafted by two relatively inexperienced parties, albeit Mr. Callan was a solicitor, what this agreement is telling us is that do not touch CIS business. But my lord, I don't think I can develop that too much further. I absolutely accept my lord's point about the language that is used.
If we look at Schedule 5, could you just help me with this, which is headed limitations of the appointor's permission, that's your permission.
Yeah.
Under each category, the first two things are not so much limitations, but the things you are authorised for, as I understand it. Is that right?
That is right, my lord.
So you're taking the first one, advising on investment. You are authorised for all those investment instruments listed, including units.
Yes.
You are authorised for eligible counterparty and professional.
Yes.
Implicitly, perhaps, not for retail, but it's a statement of what you are authorised for. Then the limitations, first one, rights to or interests in both, which appears under another one, obviously. That seems to be the only limitation, and I'm afraid I don't understand what it means.
It would be our submission to assist my learned friend. That is a reference to Article 89, I believe, in the RAO.
Have we got that?
Article.
Yes. It's behind tab 16. Have we got it in bundle?
In what?
So I'm not sure actually if we have it in the bundle.
Tab 16 of the bundle, of the authorities bundle.
I don't think it's made its way into the authorities
No, it
bundle.
hasn't.
The whole of, but in the regulated activities order, in Article 89, there's a heading rights to or interest in investments, and that obviously mirrors the language we see here. And we'll give a copy electronically.
Sorry, but what are you trying to say, Mr. Sims? The bit that my Lord Justice Males asked you about, which says both.
So there are no relevant limitations, we would say, because it says rights to or interest in investments, so it's both. So in some instances, you might have a limitation on just rights to, as opposed to interest in investments, for purposes of the investment type. So we say it's actually a reference back to the investment type, not to the customer.
Well, that seems to be what the authorisation itself is saying. If you look in the supplemental bundle, page 92, under this heading,
Yes.
limitation is rights to or interest in both investment activity and rights or interest in investment security, and rights to interest in investment contractually based investment is limited to the investment types granted for this activity.
Yes.
So what's made it into Schedule 5 is only a part of what's in the authorisation, despite the fact that it purports to be a reproduction of the authorisation.
My lord, I should say I hesitate to interrupt my learned friend, but what he's put in the bundle was not before the judge below, and is not the version of the register as at the date in time. So
No.
I'll come back to those submissions in due
So
course.
this is not, what we're looking at here is not the right authorisation.
We don't know because that wasn't explored in the court below. My learned friend hasn't produced that authorisation. But what we do know is by looking at the date of it, that my learned friend has just taken that from the register.
But your point you're trying to make, as I understand it, is that this is not a relevant limitation because it's nothing to do with units.
Exactly. So assuming for present purposes, we make the assumption that
If it's the right document, and if and all the other things,
then
it's nothing to do
exactly.
with this case. Thank you, Mr. Sims. Is helpful. Do you accept that?
My lord, I'm slightly surprised to learn that there's a question about whether this is the right document. My recollection is that our permissions were put in evidence by my learned friend's side
Okay.
in the application.
But
I don't want to weary your lordships with
assuming it's the right document,
yes.
do you accept that the references, the limitation in the actual authorisation, if it is the right document, is a limitation which has nothing to do with this case, and units is included unqualified by a limitation in your authorisation?
As to that point, my lord, yes, I would accept that. I'm looking at the register for the purposes of illustrating my point that customer type is a part of the concept of permission, therefore a part of the concept of.
I completely get that, but that's not
Yeah.
what I was asking.
My lord, I didn't want to make a concession that seemed to undercut my earlier submission,
No.
which has the point, but I don't raise any issue as regards the unit point.
Good. Thank you.
I hope that's clear,
Yes.
because I'm grateful. I was having unwisely said where I was going to go and in what order, as a consequence of the helpful interventions from the court. I need to check that I have visited all the places in the itinerary, if I can put it that way.
I mean, if you were wrong, can I just see where we are? If you were wrong about your authorisation and the authorised representative's agreement preventing the authorised representative from marketing units in a collective investment scheme,
Yes.
that destroys your first ground.
That disposes of my grandma, my lord, absolutely.
Yes. And it leaves you with the retail point
Yes.
as being a what, not a how,
Yes.
and you would put your money on that in that event.
I would have to, my lord, and I did.
Yes.
And that, if I've understood correctly, does not get you out of jail completely, because there is at least one claimant who is not a retail client. Is that right?
There is one claimant who was not formally assessed as a professional client, so by default would be a non-retail. So, my lord, yes, I think that would be right. I am not, as I stand here, aware of which claim it is.
Right.
The investments, as the Lords may have seen, were made in varying amounts, from the tolerably small to the very large. The judgment against my clients currently stands at 1.674 million. So if I were only going to obtain partial success, it would be a success that my clients would very much welcome, and it would obviously then have to be investigated as to who that claimant was and how much and so on and so forth.
Just comparing the Schedule 5 to the agreement and the authorisation in the supplementary bundle,
Yes.
there appear to be some differences, including that there are some categories which appear in the authorisation but not the appointed representative agreement.
Yes.
And there are some categories where the authorisation does extend to customer type retail investment,
Yes.
which does not appear in the schedule to the agreement. And that's
Yes.
that. There are two possible consequences of that. One is that Mr. Sims is right and the wrong authorisation is in the bundle. The other is that it's the right authorisation, but there was a deliberate decision by somebody not to reproduce it and to cut out the references to retail investors.
And if the latter, of course, my lord, that would be perfectly permissible for my clients to do, because it follows from Anderson.
Yes, but at the moment we don't quite know which of those is right, do we?
Well, no, I'm sorry not to be able to assist. We will obviously have to put our heads together at some stage and discover where the copy of the authorisations in the bundle came from. As I have said, I believe it was exhibited to Milena Friends Solicitor's statement in the application below, but if your lordships have, by some mischance, and it need not matter why, if your lordships have the wrong document, then plainly your lordships must have the correct document.
Well, there's been no application to reduce fresh evidence on appeal, so
Well,
everything in the supplementary bundle ought to have been in evidence below, didn't it?
well, I believe that's certainly the attempt that was made on my side in terms of putting it together.
Right.
But we must obviously get to the bottom of it because it's important. And I will, if I may, discuss with the learned friends over the short adjournment what we're going to do about it. But we cannot leave your lordships in a position of not knowing whether this is the correct document. I think, unless there is anything further with which I can assist at the present moment, I have covered the ground which I sought to cover, and so I will hand over to
I'm afraid I have a couple of questions.
Of course. Not at all.
First of all, can you help me about what I suggested was the tension between paragraph 38 of the judgment on page 83 and paragraph 53 of the judgment at the top of page 87. The first of them says...
sorry, wasn't the law give me a moment?
Yeah.
The first reference was...
Paragraph 38.
38.
The judge says...
Yes.
The first 7 schemes are plainly CISs. Nobody involved in them had any authorisation to operate, and there was no lawful route by which they could be promoted or marketed. So that seems... He seems to be saying that the promotion and marketing of the schemes would be unlawful. But then, on paragraph 58, he does distinguish between operating and promoting and marketing them. Bottom of page 86. And he says that they are within the prescribed categories within which representatives may be appointed. They also fell within the activities that KCL was authorised to conduct. So how do I reconcile that with his earlier statement that there was no lawful way in which these schemes could have been marketed?
I'm sorry, my lord, I've lost the second reference. Was it
53.
53.
Yeah.
Yes, this is where the judge takes the distinction between
Yes,
operation.
but at 38 he said there was no lawful way by which these schemes can be marketed. And I don't understand how those two paragraphs of the judgment fit together.
Yes, I will double check if I may with my clients, but my understanding is that 38 is wrong, in the sense that a CIS could have been marketed by my clients within their authorisation,
Yeah.
and by an AR who was given permission to do that. Now, we of course say we didn't give that permission, but
I
I
follow.
was asking at the level of principle,
Yeah.
as I understand.
Right.
But operation,
No, I understand.
we,
I understand that.
we did not
I
have
just
permission
could-
to do.
I
So
just couldn't.
the judge is half right, as it were.
Couldn't marry those two paragraphs together.
Yeah.
The other question I wanted to ask you is your supplementary skeleton
Oh, yes.
argument seems to advance a case on illegality. That if the contract is what the judge said it was, then it was a contract to do something that was illegal. And I'm not sure what consequences follow from that. First of all, I'm not sure whether the stark statements in the cases you refer to can survive Patel and Mirza, which has an altogether more nuanced approach to the question of illegality. And second, it would then lead to the question, what does section 39 mean by, quote, a contract, unquote?
Can I answer
under the old system, as it were, if you had an illegal contract, the rights and obligations wouldn't be enforced. Does that mean there was never any contract?
Well, can I answer the second one first? Very commonly, and of course in this case, and indeed in Anderson's sense, one is looking at a formal agreement. But it is pointed out by Lord Justice David Richards in Anderson that the authorisation need not be an agreement. It must simply be in writing.
Yes.
So I think the answer to my Lord's point would be, even if a contract were illegal and not enforceable as a bargain, it would still contain a statement in writing
Right.
of the authorisation. And
So
that
does that
would
mean the
suffice.
illegality argument doesn't take you anywhere?
Well, the only point of the supplemental skeleton is that it is being suggested that if we are right, all this is absurd, because everybody has been carrying on illegal activities for a very long time under this agreement because of a mutual mistake. And all we were seeking to show was that that is not a legal impossibility, and nor is it unknown to them. And so the obvious illustration is, I forget which case it is now, but Lord Denning's case of the amateur roulette game in the bar that turns out to be contrary to the Gaming Acts. And all those citations are there for is to show that it is perfectly possible for parties in good faith and without any intent to do something unlawful can enter into a contract which turns out in its performance, probably so that just in its performance to be unlawful. So all I was seeking to do there really was to meet the objection that, oh well, if you're right, we've all been carrying on blithely in breach of the general prohibition, and that can sometimes happen. That was all I was seeking to say. I'm not trying to take any more sophisticated point about illegality, nor am I suggesting that really the law of illegality comes in any further than merely illustrating that point.
Thank you.
Anything else? No. Thank you very much, Mr. Howard. Yes.
Lordships will give me a few moments just to rearrange the deck, of course.
just while Mr. Sims is rearranging, I'm told that the reference where we think we got the authorisations from is indeed, as I recollect it, the witness statement from the claimant solicitor, page 19 of the supplemental bundle.
If it assists my learned juniors, check that point as well. We accept that this version was exhibited to our evidence in the court below. My point was a slightly different one, which is if you look at the date of it, it doesn't actually necessarily match with the date of material time. That's the short point. I hesitate to interrupt.
No, I'm merely attempting to assist, but I'm grateful, and I'm sorry for interrupting Mr. Sims even before he has started. But it's paragraph 35 on page 19, and I believe, if I may be permitted the phrase, we lifted that straight from the exhibits bundle in the court below.
Yes. There's no dispute in this court as regards putting that before the court. In any event, it's a public record document. I'll come to my points in this respect shortly, but the short point is the question of authorisation in relation to whether or not retail clients could have been the subject of certain activities was not a point taken in the court below. It's not taken in the defence or in the skeleton argument, and is not in fact in my own friend's grounds on ground 2. So the point that's been sought to be developed wasn't investigated in the court below, and the relevant materials just simply weren't investigated as to whether or not, in actual fact, there was a restriction on authorisation vis-à-vis retail clients. So I just wanted to make that clear right at the outset that we are obviously dealing with Mullin & Friends grounds as framed by him, and those don't contain that point, and it wasn't investigated in the court below. The second point by way of preamble I just simply wanted to refer to is this, that my Lord Justice Lewison asked the question of how we get the route through to CISs via Articles, I think it's 25 and 53. The route through is by the definition of security in Article 3 of the RAO, which then cross-refers to Articles 76 to 82, and that includes Article 81, which includes units in CISs.
You're going to say that a bit more slowly, so
Sorry.
we can note it down.
Yes, so it's the definition of security within Article 3 of the Regulated Activities Order, which
In Article 3 of...
the Regulated Activities Order, which I'm calling the RAO for short.
Yeah.
Unfortunately, we don't have that in the authorities bundle, but you can look it up and we can provide a copy over lunch if needs be. And then that then cross-refers to 76 to 82 as
Sorry, that cross refers to what?
Articles 76 to 82.
76 to 82
Yes,
of the RAO.
RAO. And 81 of the RAO identifies units in CISs.
Thank you.
So how does that then take us back to the appointed representatives regulations? That's to do with via Article 25 of the RAO, is it?
Yes, I think it's security is the route, is the phrase.
So it's not relevant
No,
investment.
I don't think it is.
It's security.
Yes, I think that's right. Just to deal with a few other preliminary points in relation to other sort of general points before I get into my submissions proper. On ground 2 and the question of classification, Maloney Friend in paragraph 20 of his skeleton argument sought to suggest that in some way classification was concealed from his client. He hasn't advanced that submission orally, but I wanted to make clear that paragraph 20 of his skeleton argument is wrong, both factually that all the claimants are retail clients, they're not, and the schedule which was before the court and not the subject of any challenge, as I understand it, includes one investor who was not a retail client because they were a professional client. Secondly, there was no evidence before the court below that any of the classifications were hidden from his client. And of course, we're a stranger to all this. We're not JHM. We're not a counterparty to this arrangement. But no such evidence was put before the court. There's no evidence to justify that statement. So I wanted to make it clear at the outset that that paragraph is simply not correct. Moreover, and again, in paragraph 24 of Malone and Friends' skeleton argument, as I understand Malone and Friends' oral submissions, he is no longer pursuing the submission in the second sentence in paragraph 24, and he's no longer criticising the judge in relation to the alleged error in relation to Schedule 5.
Sorry, which paragraph? 25?
Paragraph 24 of Malone and Friends' skeleton argument. He refers to the judge's judgment by reference to the final words from the AR agreement. And he says, he records the finding that was a declaratory statement as to the parties' conclusions. And then he said, in this he was in error because he failed to read that statement consistently with the words in the Schedule 5 agreement, which make it clear that D1 was not permitted to advise about CIS. Now, in my respectful submission, that submission, if it is being persisted with, cannot be persisted with because Schedule 5 clearly distinguishes between operating a CIS, which is clearly prohibited, and arranging and advising in units, which is clearly not prohibited. Units, for present purposes, clearly include CIS. And so, in my respectful submission, this flaw lies at the heart of my Malone and Friends submissions on ground 1, because actually the judge, if you go back to the judgment, properly makes a distinction between, on the one hand, operation, in paragraph 51 of the judgment, and then paragraph 53, where clearly he's talking about promoting and marketing, which then obviously takes you into advising and arranging.
So how do you explain paragraph 38?
I would agree with my learned friend that one needs to treat paragraph 38 with some care. And what I think the judge was getting at there was not that KCL did not have authorisation, or indeed there was any limitation on the ability to advise or arrange investments in CISs, but that because clearly JHM could not itself operate these schemes, it was not a person who could operate, and neither could KCL. There was no way that in fact, knowing what we know and the facts on the ground, that this could have been lawfully carried out.
So you interpret that as meaning because KVB were themselves operating these particular schemes through SPV, no doubt, there was no lawful way in which these particular schemes could have been promoted or marketed. Is Is that
Not quite
your
right.
reading?
Not KV. Not. It's J. It's
Sorry,
J.
JHM,
Yes.
I beg your pardon.
Yes. So our understanding of probably what he was getting at there, reading it consistently with paragraph 53, is what he was getting at there is once you conclude that there is no one who can properly operate this, and in fact, the schemes as known by these parties was that JHM stroke the SPVs were going to be the operators, and so therefore there was no way you could do this lawfully. That's a different question from an AR agreement, which doesn't actually deal with who the operator might be. So you can envisage a scenario in which, as indeed happened later on, they got a properly authorised person to operate Kingsley Terrace. There's an argument as to whether or not they were the sole operator or not, for the purposes of whether or not actually that still meant that JHM or certain SPVs were involved in operating them. But our reading of this paragraph is that it's not to be read as being inconsistent with what
So it's scheme specific, not generic.
Exactly, yes. That's our reading of that paragraph.
Now, in his evidence, Mr. Ursell says that KCL wasn't authorised to establish or operate a CIS. Where do we get that out of the authorisation? Any of that? We've got the reference to units, which you say include units in a CIS.
Yes, I think that's the reference to establishing and operating. I think are often used together because that's a statutory reference, I think, rather than an agreement reference.
Where do we find that?
Yes,
or not in the authorisation.
I'm not sure if actually the question of establishment is dealt with in the AR agreement. I think it's more a proposition based on statutes that there's a I'll come back to that point, my lord. But from memory, it's not a concept which is specifically addressed in the AR agreement. It is a concept which is generally understood deriving from.
No, I wasn't talking about the AR agreement. I was talking about the authorisation.
Oh, the authorisation.
Which is what the evidence is referring to.
Yes. I'm not sure if the authorisation deals with the question of establishment either. I do stand corrected if your lordship thinks that it does.
I don't know. I'm asking you.
No, I certainly haven't identified that as being a particular point arising. I think the reason why it's mentioned is because authorisation is often grouped with operating for the purposes of prohibited activities. I think that's the answer to that question, rather than it being something which is either in the AR agreement or in the published register. Yes, I think it might be 51 ZE that phrase comes from in the RAO again. Is that in the bundle, in the authorities bundle? So it's not in the authorities bundle, my lord, but if you look at Article 51 ZE, the phrase establishing, operating, winding up a collective investment scheme is a phrase grouped together in 51 ZE. That explains that reference. But if I can focus back for present purposes on the grounds of appeal which my learned friend has formulated and we're here to meet, those are obviously set out behind tab 1 at page 17. And as formulated, ground 1 deals with the question of the proper interpretation of the AR agreement. And obviously we'll come back shortly to the AR agreement, but as formulated, it is as a challenge to the judge's approach to the interpretation of the AR agreement. That and that alone. I'd invite you to note that my own friend does not appear to have advanced in his oral submissions the only potentially significant point of law which is identified within these grounds, which is that the strictness of the vicarious liability imposed by section 39.3, this is within sub 3, mandates a strict construction of the words of the relevant permission. We would respectfully submit that's not supported by any authority or principle, but the question of interpretation of the AR agreement, it's a commercial agreement which merits no strictness or indeed any other approach to its interpretation. And we would submit that, moreover, in relation to section 39, one needs to remember that the section does two things. It obviously provides for exemption as well as providing for the lending of regulatory permission. And the exemption, obviously, a prohibition of the exemption has significant adverse consequences for the AR in relation to their activities. So we would submit as a matter of law, no case law or analogy or anything has been alluded to by my learned friend in his skeleton oral submissions which would support that submission.
There is another principle of interpretation which may or may not apply, and that is that where there are two realistic constructions of a contract, one of which is lawful and the other one which is unlawful, you should in principle prefer the lawful one.
There is. I don't understand my learned friend to advance that submission either. We would respectfully submit that the judge took the approach in this case of looking at what the operative provisions were in the definition of relevant business and asked himself the question, what did the parties with the background context in mind which he found meant by the specific operative words. And the additional sentence, there is no pooling, no CIS, was viewed by him as simply a misdescription by them. So we would submit that actually this case falls in the category of those cases where you have the operative clause which the judge correctly construed having regard to the context, and then you have a statement which shortly follows it, which is simply a misdescription of the thing, which can simply be, it has no effect on the operative part of the clause, because that's what the parties intended the appointor was going to be doing in fact in substance. There is probably a closely aligned principle, which is based on cases like Street and Mountford, etc., which is the court lets the substance, not the label. I think that's probably more relevant on ground 2 than ground 1. In the sense on ground 2, we're looking at not so much the construction of the AR agreement, but whether or not section 39.3, the scope of permission granted in relation to the relevant business activity can be cut down into, say, as a matter of agency, vis-a-vis the ambit of the business which has been granted permission in relation to. And that is really a question of section 39, which obviously has as its starting point the interpretation of the AR agreement. It is actually a section 39 issue where one is asking what are the consequences of, in substance, what the parties have agreed. So to take the analogy with Street and Mountford, that the relevant critical analysis is has exclusive occupation been agreed, not what label you might give to whatever that activity is. And on this, we would also invite you to conclude the judge was right in the court below on his interpretation of the application of section 39. If you look at my learned friend's grounds again in relation to this, no part of it is based on the fact that his client was not authorised to, in effect, give us the regulatory imprimatur for retail clients. The argument in the court below and on appeal is that simply retail clients should be viewed, so that the activity of marketing to retail clients should be viewed as a question of what, not how.
Isn't that where the authorisation comes in?
What,
The authorisation is authorising KCL about what they can do,
well,
not how they should do it.
what if you look at the ground 2, no part of that, or indeed in my learned friend's skeleton before this appeal, no part of that derives support from the proposition that in fact the authorised person, in this case KCL, did not have authorisation in relation to any activities.
Yeah, that's not the point I'm making, Mr. Sims. If the limitation on clients in the authorisation is a what question rather than a how question, why should the contract be interpreted differently? So as to move it from the what category to the how category.
It's a conceptual question, not a.
Yeah.
I would agree with that. I was just pushing back on the notion that the legs might be cut away from us on a logically prior question, which I think your lordship has fairly raised, but is not my own friend's argument in the court below or in this court. So I would urge you not to carry over to the question of that question, the question of the what or how. And I would also submit that as is identified by my own friend, if you look at, for example, the copy that was before the court and is before this court in relation to authorisations, in actual fact, in relation to one of the categories, which was arranging permission, it does extend to retail on the register. So it's perhaps a moot point either way as regards where that point leads for purposes of this appeal.
Is there really such a clear-cut distinction between them when the definition of relevant business in the appointed representative agreement is that for which we are authorised by the FCA, and then Schedule 5 sets out what purports to be KVB's authorisation, which specifies only particular types of investor.
I can see your lordship's point that if one assumes for present purposes that Schedule 5 is a faithful reproduction of what the authorisation is, in fact, our point is...
Well, even if it's not, it's the contractually agreed version.
And I think it probably is a red herring in any event, in the sense that the substance of the question on ground 2 is really the question of how does Section 39 operate in circumstances where, in relation to a prescribed activity, you have given permission. So, to go back to Article 25 and 53, which arranging deals in investments and advising investments, that is the prescribed activity. In essence, what Anderson Sense said was, contrary to the submission I made to the Court of Appeal, that you should simply stop there for the purpose of interpreting Section 39, that you can, in fact, cut that down by reference to not simply the whole of the prescribed activity, but part of the prescribed activity. And you can see how that can operate vis-à-vis products, vis-à-vis certain company channels. But in our respect for submission, when you come to the question of client classification, that is a question of how you perform the activity of advising or arranging deals and investments. There are certain clients who it may be inappropriate to carry out that activity depending on their classification or not. You may make a mistake in relation to that process, and that process does not just involve a clear tick box exercise, it involves a qualitative approach in relation to suitability, which is similar to the process you see, for example, in relation to assessing suitability under COBS more generally. And so what we would submit is that going back to the judge's approach at first instance is that he was absolutely right to say that in relation to client classification, that is a classic question of how you carry out the activity, the prescribed activity for which you have authorization for. Can you properly advise in relation to investments or arrange deals in investments vis-a-vis certain types of client, depending on their classification?
But the thing I don't understand about that is if you are only authorized to conduct a particular prescribed activity by reference in relation to retail clients, professional clients, and that is what you are authorized to do, then, and it's so stated. I mean, I know you say it's not as simple as that, but let's assume for the sake of this argument it is.
Are we talking about authorization in the AR agreement?
I'm talking about authorization of KCL under the legislation, under FISMA.
Legislation.
They are only authorized to sell collective investment schemes, not to organize them, but to sell them to professional clients. And they then enter into an agreement with you, which says, our authorization is in Schedule 5. It says we're only authorized to sell collective investment schemes to professional clients, and that is the business we're authorizing you to do. Why is that not part of the authorized business? And if you step outside it and go and sell it to retail clients, you're really in quite a different business environment. And since this is legislation that is designed to protect people who deal with financial advisors, one might assume that the circumscription of the business you're allowed to do and the liability for it is quite narrow. What's wrong with that argument? I mean, why is it how you do it when you're actually, they're not authorized to do it and you're not authorized to do it, if that's the proper interpretation of the agreement?
Well, my lord, I think there are a number of points I would seek to make in response to that, and one of them is that one has to start with words in section 39. That's the gateway through which we get into this debate.
Mm.
And if one looks at section 39, the operative wording is the focus of the inquiry is permit or require him to carry on business of a prescribed description.
Right, where are you looking at it?
Section 39. So in the authorities bundle behind tab 14, and if you're looking at the electronic version of it, if you're using the locator bar, it's 292. If you're looking at the continuous pagination, it's 289. Apologies, but the person who did the pagination doesn't seem to have...
Well, I was sent two bundles electronically, which are incredibly cumbersome to use because none of the page references match up. Anyway, 39.1.
Section 39.1
says permits or requires him to carry on business of a prescribed description.
Exactly.
So why is the business of a prescribed description not, in this case, selling collective investment schemes? And I'm not preempting the first point by using that terminology.
Yes.
Selling collective investment schemes to professional clients.
The reason for that is because prescribed description is takes us to next. That terminology takes us next to the appointed representatives regulations, Regulation 2, And my lords, this is, I think, established in Anderson's sense that I think my submissions to this effect were accepted by the court, that prescribed description for present purposes in section 39A1 means that the different descriptions prescribed in the appointed representatives regulations.
Where is that in the
regulation 2? That's behind tab 15.
page?
And the page is 309 if you're using the locator bar, or 306 if you're using the continuous pagination in the bottom centre.
Does it come to this, that your answer to my lord is that the description of business which is prescribed in these regulations does not include the identity of the investor?
Exactly.
Is that your point?
Yes.
But then you've got to go back to section 39. So we've got the AR permitted to carry on business of a prescribed description. But we then got to say that he's someone whose activities in the carrying on of the whole or part of that business, i.e.
Yes.
of the business, the prescribed business.
Yes.
Is something for which his principals accepted responsibility. So it's not a question of what is the business of the prescribed description. It's a question of what is the part of that business for which the principal has accepted responsibility, and that's in the contract. That's not in the statute.
Well,
isn't it?
no. One starts with the statute, and one asks oneself the question: in the contract, what business of a prescribed description is permitted? That's step number 1.
Yes.
Step number 2, as established by Anderson's sense, is that you can functionally restrict part of that prescribed description by reference to company agencies, but you can't use the contract to, for example, provide that the way you go about that business activity is somehow excluded, because that would denude section 39.
No, I understand that. You can't say in advising on investments you've got to do it carefully.
No. So, my lord, I don't disagree with the notion that the point on this appeal is really on ground 2. Does the word "in carrying on the whole or part of that business" mean that you're looking at the prescribed description activities, in this case advising on investments of the various different categories we see, and particular product types which you see? The court said, well, you can limit that by reference to the product provider, which is a particular type of product falling within that business. But of course, Anderson's sense does not support the proposition that the type of customer is a functional limitation on the part of the business of the prescribed description. And so the short point is, and the point on this appeal is that on ground 2, that we submit that actually the judge was absolutely right to say that actually, if you look at the activities carried out in relation to classification of a client, that effectively overlaps with, is similar to the concept of the quality advice which is being given. We know the quality of the advice which is being given itself is not excluded, because my own friend doesn't answer that proposition, and Anderson's sense acknowledges that. And we would submit that as a matter of proper interpretation of this section, what it's really getting at is a field of activity which you can carry out, the business which you can carry out of a prescribed description. That is your field. You may have particular product channels within that field you can say you can take out. But what it's not dealing with is either the status of the authorised person or dealing with the status of the end client.
I must say, speaking for myself, I don't really see the difference. You've got an authorised person who says to the AR, well, I really don't trust you to choose from a vast variety of unit trusts which you can offer advice on. So you've got to use these three. And somebody who says to the AR, well, I just don't trust you to explain the complexity of these investments to the man in the street. You can only deal with professionals. Well, and there's no real difference there. As Lord Justice David Richards says, it may make perfect sense to limit an AR to a partial exemption, having regard to the breadth and depth of the expertise of that AR. So you're expert enough to explain this to somebody who knows the jargon, but you're not expert enough to explain it to somebody who walks in off the street. What's wrong with that?
Well, I'll come back to that particular point in the context of submissions I make in relation to COBS 3 after lunch, probably. But so we say that actually, if you look at the experience point and the assessment of whether or not someone is a professional client or not, that very substantially overlaps with the same question of suitability and quality of advice. But there's a logically anterior point which I don't think is addressed by that passage in Lord Justice David Richards' judgment, which is what is Section 39? What are the ambit? What are the limits of Section 39 in relation to the business? What is Section 39(1) getting at? And if you start with Section 39(1)(a) little Roman numeral 1, it is getting at business activities of prescribed descriptions. That's our starting point. Yes, you can agree to restrict that by reference to part only of the business following Anderson and Sens. But the person who is giving the advice or receiving the advice doesn't form part of the functional definition of the business. The functional definition of the business can include a carve out in relation to products because they're a particular type of the investment type which is contemplated as part of the business activity. So, contrary to my submissions before the Court of Appeal, it's impossible to distinguish between what and how. You can distinguish between what and how effectively if you remember that what Section 39(1)(a) little Roman numeral 1 is directed at is an inquiry as to what is the substance of the business activity for which the authorised person has agreed the appointed person can carry out by reference to the prescribed descriptions or part of that prescribed description. And you can, by reference to company agencies, effectively say that is part of business of a prescribed description. You cannot do that as a matter of language in relation to the end client. It doesn't form part of the investment activity or investment type, which is the tree below which you get to the business description. And so, on our submission, we respectfully submit that that is the proper approach to the statutory construction. The second point, which I think was wrapped up with the question I think my Lord the Master of Rolls put to me, was the question of what approach should you take? Should you take a narrow or broad approach to this particular exercise? So far, the authority suggests a broad approach. That may be a job for me for after the short lunch and adjournment. But so far, the authorities tended to take a broad approach because of concern that there is often close proximity or overlap between regulated activity and non-regulated activity. So can I briefly reverse back and just deal with some submissions on ground 1 and then take my submissions on ground 2. I'm conscious of the fact I've been darting around a little bit, but hopefully those introductory observations have been useful so far as what we say on the main grounds. On ground 1, our starting point is that on this appeal, it's common ground that the issue arising is one of construction, and as I've already sought to make clear, there is no principled basis for and no authority for the basis that you apply a strict approach to the interpretation of this particular AR agreement. The second point we would make is that the judge applied orthodox principles of construction, having regard to obviously well-known authority, which I don't need to cite to this court, in construing the AR agreement in context and having regard to findings he made as regards the relevant factual background known to both parties and as found by him. Now, my Lord Justice Mayall put a scenario to my learned friend as regards a certain fact pattern whereby the parties know the characteristics of the particular scheme which they are intending to implement, but wrongly state it to be not a CIS. And my learned friend sought to suggest, well, that's not the case before this court. We would fundamentally disagree with that submission. This is absolutely this case. The judge found that the very thing which was in contemplation here were the schemes which had the attributes identified in advance and which were implemented in the same way. This is not an Anderson sense case where there's some covert operation by the authorised representative which is hidden from the authorised person. The judge found in this case that the raison d'etre to this agreement was to promote, advise, arrange in relation to these very schemes. There is no challenge to that by my learned friend. So the logical conclusion reached is that this was precisely what happened in this case, that the parties simply wrongly stated and wrongly attributed the legal consequences of the characteristics of the schemes which they agreed were going to be carried out and authorised to be carried out under the AR agreement.
If we are looking at this as a matter of interpretation of the agreement,
yes,
which I think is what you are saying,
yes,
we are concerned with what the parties knew at the date of the agreement,
yes,
right?
Yes.
Not what they did afterwards.
No, you're quite right.
And what we know about their knowledge at the date of the agreement, I think, is contained in paragraphs 7 to 12 of the judgment. Quite a lot of the way in which the schemes evolved seems to have taken place after the contract was made. Is that right or wrong?
No, I think that's a mistake. I think there was an evolution before the slightly complicated fact background, because JHM was originally an LLP.
Yes.
And it carried out property refurbishments. It then became a limited company and carried out more ambitious development schemes. So yes. The shift was from an LLP to a limited company and a new AR agreement with that limited
yes.
company.
Well, we've got the business plan which the judge describes at paragraphs 9 and 10. That's during, that's while the LLP was just before
yes.
the LLP was the AR. Then he says in 12 there was a decision to restructure. There's no substantial documentary or witness evidence about how that happened, and no revised business plan. So we're still looking at the business plan in 9 to 10. And that results in the agreement we are concerned with, entered into in June 2015. So if we are looking at this as a matter of interpretation of the contract, why are subsequent events relevant?
Because the judge went on and made later findings in the judgment that actually the parties contemplated, as at the date of the agreement, the same schemes which were in fact operated. So that was a finding of.
Is that a finding that he is deriving from what he says in paragraphs 9 and 10? Because
No.
it doesn't identify, as far as I can see, anything else which happens before the contract was entered into.
Well, I think there are some later passages which we can see.
Well, I think
there.
maybe we can deal with those later passages after the short adjournment. So we'll resume at 2 o'clock.